And Mr. Jones is charged in cause number 25 DCCR 0523 with the offense of murder. And Mr. May. And in cause number 24 DCCR 2431 with the offense of unauthorized use of a vehicle. Mr. Wilkerson has filed a motion just in the murder case, correct? That I reduce the bond.
Yes, Your Honor.
Whoa. $800,000 bond? That's not pocket change. But here's a legal twist. The defense is asking to reduce it, even though this is a murder case. Question for the comments. If someone's already been locked up for months and wasn't the shooter, should their bond reflect that toward? Does the entire crime still stick like glue?
I believe it's at 800. I remember.
Pull it up so we make sure.
Let's quote because I have had several.
It looks like in the motion it shows the murder is set at $800,000. And Mr. Wilkerson, do you intend to call your client or other witness?
Your Honor, I just intend to call my client and then also Benicia Jones, if she is present.
Mr. Johns, best you can, raise your right hand. Or Jones, I'm sorry. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can go ahead, Mr. Wilkerson.
Ms. Jones, you are obviously the same John Jones charged in this case with murder. You also have a companion case in which you were charged in a separate offense with unauthorized use of a motor vehicle. Is that correct? And how long have you been incarcerated? 3-4 months. And during that time, has that time you had the murder charges pending during the entirety of that time? Is that correct? Now, the person who actually pulled the trigger with regard to this offense has pled guilty and been sentenced. Is that correct?
Okay, plot twist. The actual shooter has already pled guilty and got 30 years. So why is Mr. Jones still sitting here with murder charges? This is what we call felony murder, theory guilt by association. Let me know if you think that's fair or if we're stretching justice.
And that was to 30 years. Is that correct? And he was on parole at that time, correct? And until previously, at least as of the 24th of July, you had been off 35, correct? Alright. Now, during the time that you have been incarcerated, you've had some run-ins with staff with regard to some behavioral issues. And obviously, if the court is going to consider lowering your bond and how you would be able to behave or would behave in the community at large, were she to grant a reduction in your bond, there are some concerns. And so we'd like to give you the opportunity to speak to those concerns, and I would encourage you to emphasize conditions that the court might be able to impose that you would be ready and willing to follow that might curb some of those concerns for the court while this case remains pending.
Go ahead.
Wow, the write-up thing going around, I didn't have my proper medications. I was supposed to be seeing a psychiatrist to take my proper medication. I feel like if he was to give me a bond reduction, and I was to get those recommendations, and I was to make bond, I would follow the rules because I take my medications now, which are for my anxiety, depression, things of those nature. So I feel like harm reduction is necessary.
So you have your medications now?
No, but I should have by the 21st.
So what? I mean, anxiety and depression don't make you say things like,
Here's where mental health steps into the spotlight. Lack of proper medication isn't just a health issue. It could make or break your behavior profile and influence the judge's bond decision. But the court's not buying it easily. Question: should jailhouse behavior influenced by untreated conditions be considered when setting bond?
Not even gonna sit here and properly. I never said those things, but
you didn't say those things? You didn't ask her how could she have a boyfriend with how ugly she was? You didn't ask how many boyfriends she ever had? You didn't say any of that. They're just making that up on you. Just lying. Have to be lying. You didn't threaten just a couple weeks ago an officer that you were going to throw hot water if she didn't call somebody? You did threaten to do that? Okay. Did you say at one point when y'all were getting in trouble that it had to do with somebody giving a Bible back to another person, and you inserted yourself in something that wasn't about you, and you said, that's what's wrong with y'all officers. Y'all think we on y'all time, and I'm not. So you don't think you're on their time when you're in jail?
I never said that.
You didn't? They made that up too?
I said was respect is given both ways. That was my exact words.
Respect is given both ways. And so you think you deserve respect with how you're acting. I got pages of incident reports. And it's pages only starting in June. We're talking about pages over just the last 2 months. Fighting. You've been in at least 2 or 3 fights, right? Yeah. Mr. Coleman?
Your Honor, Mr. Jones, what did you do with the weapon after the next shot?
Gave it back to Green.
And when did you and Green decide to rob me?
Objection, Your Honor. These questions obviously go to the guilt innocence aspect of
I think
this.
you opened that door when you asked him about the shooting and who the shooter was. And the co-defendant.
When did you decide to rob him?
You never decided to rob.
So Green said you decided to rob him before you shot. You would be lying? Yes or no? Yes or no?
Okay.
You knew the police were looking for you after Mr. Nixon had been shot, but nevertheless you didn't turn yourself in.
I didn't know. So after the fact.
When Lenny Nixon was murdered as part of this robbery scheme with Green, you were already under or on bail for UUMB, 2 cases of UUMB, and also a burglary of habitation.
No, sir, never bailed out.
You were charged with those offenses.
Yes, sir.
You also previously arrested assault on a public servant, criminal trespass, another UUMB, evading arrest, another evading arrest for motor vehicle. All included in your.
This is the courtroom moment where the rap sheet hits the fan. Multiple charges, evading arrests. Assaults, this isn't just a messy record. It's a full mixtape. Judges will weigh that, especially when bond reductions are on the table. But juvenile record versus adult crime, should it all count the same?
Yes, you're correct.
Yes, sir.
Who is Benicia Jones? Pass witness.
Thank you. Go ahead, Mr. Wilkerson.
Yes, Your Honor. We've got to circle back over some of those. Just to be clear, Mr. Trevor, not Trevor, okay, Nixon was the gentleman who was shot, correct? And you were staying at Nixon's house when Trevor Green came here. Is that accurate?
Yes, sir.
And in fact, and Trevor Green initially told officers that you had discharged the weapon that had killed Nixon, correct? However, even he corrected that statement ultimately and admitted that it was he who had the weapon, correct? And on that evening, he took your phone, correct? And he provided you the firearm that had belonged to Nixon, correct? Now, you were asked about an agreement to rob Nixon of a firearm, and whether or not an agreement was ever reached. At what point, or at any point, and if so, how did you learn of Mr. Green's intent of removing or taking a firearm that had been in Nixon's possession?
It was about that morning. Well, I'm gonna say around that night, 1, 2 o'clock.
What do you? And you say around that night, 1, 2 o'clock. What is it exactly that you were told at that time?
Nixon keep pointing the gun in our face. Let's just take it.
And how did you respond? And so, just very briefly, you yourself, Trevor Green and Nixon, had the three of you grown up together?
Yes, sir. We all went to the same school at one point.
Now, Trevor Green had just been released from prison, is that correct? And is it the case that Trevor Green was actually coming into town to spend time with yourself and with Nixon? And Trevor Green, when he came into town, he was with his girlfriend. Is that accurate? Okay.
Okay, we're not gonna try the whole case. I gave you some leeway. I gave him some leeway. I'm not gonna listen. I understand there's obviously some differences in opinion as to what happened and who's culpable. So that's all going to be for a jury or for you guys to work out.
For just a couple more in a totally different direction.
Totally different direction.
All right. Now you said you were getting your medications on the 21st. What medications are you speaking of?
I'm supposed to be taking trazodone, hydroxyzine, Wilkerson, and they're supposed to be giving me another type of med for me hearing and seeing things.
So while you have been incarcerated at Jefferson County Correctional Facility, the psychiatric or psychological staff provided by contract have made a determination that you actually have audio or visual hallucinations. Okay. Your Honor, as a result of that, we will need to request.
Just file the appropriate motion.
Yes, Your Honor.
Hold up. Now we're entering psych evil territory. Jones is reportedly hearing and seeing things. Mental competency is now in question. Declared incompetent, the case could pause completely until he's stabilized. These are big legal gears turning. This isn't just courtroom drama. It's strategy.
I'll pass.
All right. And you said you had another witness. Can you proffer what that witness would be testifying to for me?
Your Honor, that would just be his mother, Bernicia Jones, and to the little bit of support that she would be able and really the inability to raise funds.
Thank you. Okay, thank you. And I'm glad she's here. Thank you. Thank you for being here, ma'am. Okay, anything else?
Just a really brief argument.
Go ahead, sir.
I filed it. I put that argument to make clear in the state's reply to the defense counsel's to reduce the bond, so I'm not going to belabor it. I just hit the high points, Judge. If the court is so inclined, the state constitution, the Texas Constitution allows you to hold this defendant without bond because it's a felony while on bail. I cited the case law attached to my reply.
I don't see the reply on this case.
It would have been filed on August the 6th.
see a couple of things. I see an order. Oh, never mind. It's right here. Sorry.
I cite Article,
Yeah.
Article 1, Section 11 of the Texas
Got it.
Constitution. It states that if the defendant is on a felony, on bail for a felony, and commits a subsequent felony, the court is well within its discretion to hold the defendant without bond if it so chooses to. And I've proffered to the court that I've spoken with the juvenile probation, with the juvenile department division of our office, and they have begun the process to certify this defendant as an adult, and that early rehabilitation is on its way. Should be making it to your court soon, Judge. We've got the criminal history there. I think it speaks for itself. Your Honor, we'd ask that this court motion for to reduce the defendant's bond. In fact, if the court is so inclined, we ask that you move on, Judge.
Thank you, Mr. Coleman. Mr. Wilkerson, argument.
Your Honor, I think that if you look at all of the incidents that were mentioned by Mr. Coleman, that are all juvenile incidents that have occurred with Mr. Jones, that it is quite clear in conjunction with some of the things that have also been mentioned, and also it fits into some of the write-ups that have been received as well, that Mr. Jones apparently does suffer some mental illness issues, and perhaps maybe we should hold this in abeyance until we can have that properly addressed in order to give the court some additional comfort that some of these behavioral issues might be more appropriately addressed.
Here's what I'm inclined to do at this time. I'm not going to hold the motion. We can always, if circumstances change, file a motion, and I will allow another hearing if there's a change of circumstances. Today, based on the nature of the offense, based on the amount of and nature of the incident reports from jail, based on the amount of and nature of the allegations of criminal history as a juvenile. Mr. Jones is 17, about to be 18, right? So, based on that, all of that, I am going to deny the motion to reduce the bond at this time. Obviously.
And there it is. Motion denied. No bond reduction. The judge lays it out. Criminal history, jail behavior, mental health, the whole picture. This is a classic example of how pretrial behavior can shape your future. Think the judge made the right call? Let's debate it in the comments.
It sounds like the jail's doing what they can to get Mr. Jones help. If you want to file a motion with regard to any other competency, whatever you want to file with regard to that, get that filed, and I'll take a look at it as soon as it comes through. All right, you go back with the bailiff and listen, Mr. Jones. Whatever issues you're having, none of that, in my opinion, coincides with how you're behaving, right? So you need to make an adjustment of what you're doing in jail. And if you don't, then Mr. Wilkerson's not going to have any argument whatsoever for me to reduce your bond later or anything like that. So I've probably talked to just about everybody in that dorm, I think, in the last couple of weeks about this behavior. Y'all can all continue to act like you're acting, and y'all can all sit there and wait for your cases and then go to prison or whatever happens. Or somebody can step up and say, I'm not going to act like that. I'm going to get up when I'm supposed to. I'm going to follow the rules. I'm not going to fight. I'm not going to call names. I'm not going to, all those things. It's not that hard. Just follow the rules. You may not like them. Follow them. If you can't, then stay in